back to the show. This is The Law Show on CL 650.
Just see those sleigh bells jingling, ring, ting-a-ting-a-ling, too. Come on, it's lovely weather for a sleigh ride together with you.
Less than 2 weeks to the big day. Welcome back to The Law Show. Sterling Fox joined by Joe Murphy, QC, and Bill Dick, partner, and Murphy Battista, the personal injury law firm in Vancouver, and now with offices up in the Okanagan and Kelowna. Bill's down from the interior for the second visit on the program. The office has tripled in size since we saw you last. I don't know whether that's good. I mean, it's good for the firm, but gosh, that's an awful lot of personal injury business in a relatively speaking small area, Bill.
Well, you know, it's actually not that small of an area. I mean,
because you take in the whole Okanagan,
of Valley, course. which is growing quite significantly in terms of size, and so there's lots of work to be had.
We're talking about liabilities. It's party season. Who doesn't know that already? Some people listening to us this morning, turn it down. It's just a little too loud. Because, of course, they stepped out at last night. We talked about the liabilities and responsibilities as they affect commercial people, bartenders and restaurant owners and servers and so on. We've also talked about private parties held at the house and so on. There's another drinking scenario that occurs quite frequently at this time of year, and it happens at work. You know, I'm just going to stop by, I'm going to say hello to a couple of clients on my way home. And so you stop off at the client's place of business, and you're in the boss's office in the back room, and out comes the jug, and you tell him, Merry Christmas, and off it goes. And, sooner or later, somebody's going to drive home. They're probably all going to drive home. But in the case of that drink at the office, Joe Murphy, who's the boss of a large office full of people and would understand the proprietor's liability issues, what are the liabilities or responsibilities of the person who runs that business?
Well, Sterling, there was a case some years ago in BC of a young fellow who, following the completion of a project at work, then was provided with a bunch of beer, and this group of people, mostly young, to celebrate how well they'd done this project, started drinking beer, and he had several beer, and he left there intoxicated.
Which essentially was the workplace, that's right?
Yes.
Okay.
He then went to a bar and had more to drink, and on his way home a terrible accident happened. And in that case, the court found that the employer who started the ball rolling by serving a lot of beer to this group of young people who had finished this project was responsible in part for what happened, because they began the process of this fellow getting drunker and drunker, and in the end there was a disastrous accident and terrible injuries.
So in terms of the findings against the business for sort of starting the ball rolling. Now, the guy went to a bar afterwards and got really tanked. So was there a qualification of the responsibility of the company? You would be 30% responsible, and the rest of the liability falls on the young man who carried on after he left the workplace where you served him.
The fundamental issue in negligence law, Sterling, is that an individual, an adult, is responsible for their own actions and their own decisions. So that's fundamental.
Okay.
This young guy had too much to drink at work after they finished the project. He had too much to drink in the bar. He made the decision to get in his car. So he is responsible.
Right.
And the issue in that case is, well, is the employer also responsible in part for what they got the process moving?
And the court said yes.
Yes.
And so, but in the consideration of the award or damages, and I don't know the proper legal term, but would there be a reduced amount because the employer was only partly responsible for that accident later in the day?
Yeah, Bill, was that 75% the employer?
The employer in that case was found to be significantly at fault.
Oh, really?
And I think it came as a bit of a surprise because bars generally are found to be somewhere between 25 and 50% at fault.
Right.
And in this case, the employer was found to be 75% at fault. The judge,
that's what I was after, was the number. Yeah,
and the judge in that case said there's an even higher onus on employers to ensure that their employees are safe than a commercial host would. And in this case, they knew the young guy was driving because he lived far away from where he was working. So
Right.
they knew he was driving. And they actually provided the alcohol in a situation where he probably felt compelled to drink it because it was kind of like everyone, hey, let's all get together and have
Team
drinks.
moment.
Team moments.
Yes, yeah.
And in those factual situations, the court said an employer has a really high duty to monitor how much they have and a responsibility to make sure they don't leave in an unsafe way. And I think it was a real message to employers.
Right.
You're going to be found to be highly at fault in those circumstances.
That's very interesting because, of course, this is the time when it's pretty typical that people with desks and offices have a bottle of something in the big drawer on the bottom and are quite happy to share, and especially on Fridays heading into the weekend, and if you're going to take a bit of a break over the holidays, have a few pops and, wish everybody well. It's that time of year. So, but there are real liabilities. There are real legal issues, knives hanging over all of this scenario. Joe, how do people? Obviously, the easy way to avoid any legal issues is don't do it. But if you want to carry on, any tips? Any thoughts?
Well, Sterling, the message that I see that comes from these cases is when you get someone drunk, you know that they're going to go out and probably make or possibly make some bad decisions. Mm-hmm. And in the case we talked about, the fellow made the bad decision to go out and drink even more.
Right.
So when you get someone drunk, you have a responsibility, they do as well, for what bad things might happen. The solution might be, the simple rule is if you want to give people a drink on a Friday afternoon, and we've often done that in our office.
Oh, sure.
We don't have an unlimited amount of alcohol.
Aha.
We have enough that maybe people will have 1 or 2 or 3 glasses of wine, and that's it. It shuts down.
Right.
If we said, here's a case of wine and let's have music and bring in some food, then I think we become responsible for people who are intoxicated, who go out, and intoxicated people make bad decisions.
And, of course, Bill, the other option to the employer is, instead of cracking that bottle of wine, give it to the staff person and say, take it home and enjoy it for dinner tonight. Enjoy it over the holidays. So everybody gets their drinks, just maybe not on the job or in a situation where they can cause some trouble on the way home.
That's right. And I think what Joe is saying, and the smart employer has policies and procedures. Especially big employers where they say, okay, if we're going to have drinks on a Friday, no more than 2.
Right.
Or they do have an obligation to monitor. That's the whole thing. And you don't want to have an open bar. You just don't because you can't monitor them.
Right.
And in the Nike decision that we talked about and the Ontario decision, there were open bars or they didn't know how much they had to drink. And they said you have an obligation to monitor and to make sure that they don't leave drunk. And in those circumstances, take their keys away. Have some policy in place where if someone does somehow get through the cracks and drink too much,
right,
you know it, and you take active steps to prevent them from getting in behind a wheel.
But I guess moderation being the key in the first place, Joe Murphy, with just you limit the amount of alcohol that could be consumed on these occasions, so you lower the risk considerably.
Yeah, and Sterling, I've got a friend who can drink a lot, and when he starts drinking a lot, up to a certain point, you could say to him, give me your keys, let's be safe, and he would.
Sure.
But if he gets beyond that limit, he won't give you his keys.
I know people like that too.
So you've got to say,
yeah,
okay, we're approaching that limit. Let's get him to give up the keys, because if you go beyond that limit, again, making bad decisions because he's drunk, he says, no, I'm not giving up my keys. I'm driving.
And what's interesting is that Ontario decision that I was speaking of, the court actually said in those circumstances when something like that would happen, you actually have an obligation to go as far as phoning the police.
Oh, you, the employer or the homeowner, knowing that this guy is now instantly a public menace. If you don't
say
something
themselves as well.
Okay.
Yeah. And
then so if you don't alert the police that this guy is out there, then you're doubly liable almost.
Potentially.
Interesting stuff. Our guests, Joe Murphy and Bill Dick from Murphy Battista, Vancouver personal injury lawyers at 650 West Georgia Street downtown, and online at murphybatista.com. Lots more still ahead on The Law Show. Back after this.
There's more of the show still ahead. This is The Law Show on CL 650.